Yes, good evening to the everybody. That is SLW600. Karibu Sana, you are welcome to the class. And today is the first class, maiden class from Mohindi. That his name is Professor Dr. Mohammed Saheb Hussain. Yes, anyone can unmute and read which I posted on the screen. Could you see my screen? Anything is visible there on the screen? Anyone? Participants? Could you see it? Ali Kishari. If you happen to see it, please read what I posted on the screen. Haraka. Don't waste the time. Unmute and speak.
What I see is a book which reads as Advanced Legal Theory. This chapter
Anyway, I will read it what I posted on the screen. Don't worry that. And today is the legal method class, and it is just LW600. And the timings I mentioned over there Tuesday, and by the Dr. Me, which is Dr. Mohammed Saheb Hussain, Professor of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. So, without wasting the time, let me see that first chapter, first thing is concerned. It says about if you happen to have the syllabus with you, and you can see the syllabus. The first chapter, first content is said to be the legal methods. Yes, mute. I'm getting the sound. Mute. You mute. When you speak at the time, you can unmute it. When you don't want to speak, you can mute it. Otherwise, I'll get the sound here. Okay, now let us go further. If you see the legal methods, you are studied in your LLB course also. Am I right? Say yes or no. Say yes or no. Did you study the legal methods in your degree? But why you are keeping quiet? Yes. Now, in the legal method, you could see that first and foremost thing is the source of law. And next comes the classification of law. And these are already we studied over there. And much light we not throw on this aspect of it. When you say the source of law, what are the source of law would be available to you? Anyone can unmute and give me the answer? Of course, the people, those who are here is, they opened both the things, I believe. No one is from far away. Babiana Kilio, are you present here? Ali Kishari, are you present here? Good luck, Luginga. Okay, means those all present over here. I want to say that who is from the back. No, he will they read it. No problem will be there. Okay, you can give the answer to my question because it should be reciprocal in nature, not the sermon class that I will teach and you will listen. No, I will teach and I will explain you, and you have to say the answer to me. My question. Now the question comes over there. Everything will be recorded here. Whatever you speak. Whatever you speak, everything will be recorded here. Yes, now let's the first and foremost, the intelligent person is only the CR. Presumption. Is a presumption is there. So now let us ask our Rosta, what are the source of law in Tanzania? Say loudly. It will be recorded.
Yes, sources of law in Tanzania. Number one is constitution. Number two is statutes. Number three, precedents. Number four, Islamic laws. Number five, common laws.
Do you think that common law also comes here?
Also customary laws.
I appreciate. But there is a sequence. A sequence should be there. Am I right? Okay, it doesn't matter. Even though there is no sequence, but he was given the source of law. Total. The sequence goes in this manner. The first and foremost, grand noun. What is meant by grand noun? Anyone? Constitution is the grand noun. Okay. Who said that wording? Who coined the grand noun? Person. Can I say it's a Kelson? Kelson. Okay, forget about it. So anyway, that we'll see it. The windy lama is waiting for the lobby. Okay, let in. So the first and foremost is the grand norm, that is the constitution. And when you say the constitution, it's a written constitution. Am I right? Tanzania constitution is a written constitution. Of course, I don't ask how many articles are there now. Can you tell me? Oh, mute. Mute. Because there is sound. Or you can use your. You can use this. You can use this one. I don't hear the sound. I don't hear the sound. Yeah. And you can speak also from there. Yes. The longest constitution in the world. Still somebody did not mute it. I'm getting the sound. Mute. Everybody, those who are, I can say here. Yes, anyone can give me the answer? Which is the longest constitution? 5761-234. Now you muted it. Bibi and Akilio, I could not see your microphone. Try to mute it. Okay. The longest constitution in the world is? Mishibiwa, if you know it, you tell me. If you don't know it, you say pass on. Anyone in the class? The longest constitution in India. Not India, I already told you world. I already told you. The longest constitution is, Indian constitution is the longest constitution. It is several times, at least 105 times it is amended. Can you tell me which is the shortest? Of course, people say it is the USA. But people say the USA constitution is the shortest. But no, Indonesia. In the wordings, it is the shortest. But in the implementation is concerned, they did not implement it. Hence, generally they will say the USA constitution is the shortest constitution. And it is amended very less times. So the constitution is the one of the source for the Tanzanian law. So constitution also source of law in Tanzania, and also passed by the legislator must conform to the constitution. How this constitution can be made? Constitution can be made by the people, those who are an expert, by taking the expertise from the various other countries, and they will make the constitution. Before they are making the constitution, they will give the white paper to the other people to see if there is any lacuna is there or not. So that it will be, lacuna will be removed over there. So, anyway, the overall constitution is made, and that will govern it. In one way, in another way, what I want to say is, constitution is a hub. You know bicycle. Najua bicycle. Hub. Najua hub. The hub is there in the center and passes the axle to the hub. From there, spokes will go to the rim. So, constitution is like a hub. HUB hub. And the other laws are statutes, spokes. Joined to whom? Society, rim. Rim is a society. Of course, a rim goes with the tube and tube tire. Of course, nowadays the tubeless tires are there and it there. So, any law which is made in the particular country, which is contrary to the constitution, is null and void. I repeat, any law, any enactment made in the country which is against the articles of the constitution, it becomes null and void. Who makes such a thing? Who says null and void? Anyone? Say loudly. Judiciary will say. A court will say. So now, in one way, in another way, whether the parliament is supreme or the judiciary is supreme. When you come to the challenge, judiciary can make null and void. Even the parliament makes a particular law which is in contravention with the constitution. But a judiciary cannot change the law. It will only say null and void, and they will say recommend it. Better that provision should be removed. So 2 participants are in the lobby. Okay, I wrote them. Because I will get the notification here. I have to see time to time here on the screen also. Online, those who are there, are you hearing me? Say yes. Mute, unmute and say yes. I appreciate it. Yeah, they are listening to me. Yes, when you speak, you can unmute it. When you don't want to speak, at the time you can mute it. Okay? Oh, it is a beginning for you. Doesn't matter. Sooner or later that you will understand my way of teaching, and later only you appreciate me. In the beginning only you are saying no. Definitely you will appreciate me. In one way, in another way. Okay, and let us come to the point again or back. We are discussing the constitution. If any law made, it is the judiciary which will make it null and void. But judiciary cannot change it, but it can give the advice. I don't know the Tanzania. Do you have the law commission here in Tanzania? Please mute. I'm getting the sound. If you want to use it, use the earphone. I know it because I get the sound here. Yeah, if you want, you can use it. I can provide earphones. People are looking for. You have to return me. You can return me if you want. You can use my phone. So I was supposed to bring your earphone also with you, but I thought the earphone with you because accessories are must. How could you bring the phone with only a charger? It is also like that. Accessories should be must. You should bring it. Okay, let's come to our point is concerned. Judiciary is the supreme because it can say nothing. Excuse me. I don't know whether you know it. Somebody did not do it. Okay, come to the point. Government Proceeding Act 1961. If I read the mistake. You read it in the law of chart. There section 6 FIAT Fiat. The wording is FIAT Fiat. If you want to sue the government, means Tanzania government. Please mute it. I am getting the sound. I don't know who did not mute it. If anyone wants to, Babiana Kilio, mute it, please. Petrolina Chuma, mute. That's a problem. No, in the beginning, it's a problem. Otherwise, other people, no problem at all. No problem at all. Because they are habituated, accustomed, acclimatized. Yes, she now moved. Section 6 of the Government Proceeding Act, there is a fiat, FIAT fiat. If you want to sue the government, you have to give the notice to the government, and a reply should have to come from there. A reply should have to come from there. Up to that extent, you are not supposed to sue the government. Can anybody give the consent to chop my hand? Answer no. Answer no. So afterwards they say the section 6 is in contravention with the constitution because rule says everyone is equal in the before of law. In the articles, equal protection of laws and equality before law. Excuse me. That's why section 6 is struck down. And they said, instead of you give the notice to the government and wait for 3 months, then you can file a suit. Then you can file a suit against the government. Because we will come across in the law of tort case law. I don't know whether you read the case law. The teacher, I have forgotten the name, Babylon. Where you are coming from Dodoma, going to Iringa, Babilina, there is a place, Babati. Is it Babati? Like that, the school teacher wants to sue it. The case law is there. They said, yes, give the notice for the 90 days, enough. Then you can sue the school teacher because the school teacher is a government employee. Are you following me? Yes. So why I am giving this thing is Constitution is a supreme, no doubt. But the Constitution, the Parliament which made the Constitution or any other statute which they make, Parliament will make it out. If it is any contravention with the Constitution, then it becomes null and void. So that is the example which I want to show you the thing. Yes, I get in, yes. Now let us go move further. Generally we will say, particularly we don't say sections to the Constitution. We will say articles because a high regard would be there. We cannot say a teacher to the university faculty. What do you say? You can say professor, assistant professor or associate professor. But lecturer ipo. Lecturer, senior lecturer, associate professor, professor. In India, hapana, assistant professor, associate professor, professor. So, of course, there is a nomenclature is concerned. Then, any article, I say article, because a reference would be there, because the Constitution is the grand norm. And for all the international instrument also will say articles. I don't know whether you say in the Law of Limitation Act. Do you have the Law of Limitation Act? Hapa. In some portion you say sections, in some portion you say articles. I don't know whether such a thing is there or not. But in India, yes. Some portion will say articles, which are rules and regulations again. And some portion will say sections. The Law of Limitation. And that is the reason. Here they said Article 64, Sub-Article 5 of the Constitution of United Republic of Tanzania allows. Oh, don't open it. You want, you can use my. Because here you sat here. That's why I'm getting the sound. Suppose you are a Junde. If you are there, I don't get the sound. I don't get the sound. If you are here, that's why I am getting the sound. Yes, Article 65, Sub-Article 5 of the Constitution of the United Republic of Tanzania allows us the conform to the Constitution of the United Republic of Tanzania. Therefore, the legislature can only pass the law which can not contradictory or contravention the Constitution. Yes, just before I say, any law passed by the Parliament, it should not be contradictory and contravention. There are two different terminologies. I don't know how many people knows it. Contravention and contrary. Both the things are there. Of course, both the things are nothing but interference with the constitutional articles. Like we say, wrongful restraint and wrongful confinement. There is a difference. Wrongful restraint means one way you are not allowed to go. Other way you can allowed to go. But wrongful confinement means you cannot allowed to go because you confined from the four corners. So that is the idea behind there. So they said if anything is the contravention and contrary to the articles of the Constitution, that is why some others argued that Tanzania there is no parliamentary supremacy but a constitutional supremacy. Somebody say there is no parliamentary supremacy, it is a constitutional supremacy. The constitutional supremacy means who will interpret the Constitution? Who will interpret the Constitution? Judiciary, court. I don't know, you studied the interpretation of statutes. Did you study? Interpretation of statutes. Why you are keeping quiet? Either you say yes or no. Do you have separate paper interpretation of statutes? I saw there is no separate. It is there in the legal method. It is there in the legal method. Interpretation of statute. But in India, separately we study it. Interpretation of statutes. And interpretation of the statutes, a full discretion is given for the judge. Interpret by following the certain rules. I don't know whether you remember the rules or not. Golden rule, lineal rule, purposive rule, mischief rule. These are all that is called hidance rule. Mischief rule is said to be the hidance rule. Then internal aids, external aids, language canons. These are all, we'll use it when you are interpreting any language of the statute. The word of the statute. That's why you don't come across in the sister, Sinjo Kidogo Kidogo. Apana. When the Sinjo comes, no, you have to make your eyes like this. So, okay, I'm Nashida, no problem at all. So my point is, when you are interpreting it, interpretation also plays an important role, and that is the judiciary will make such a thing. Yes, these are all the rules are there where it can be interpreted. And as I said, yeah, because if you check, it will be recorded. It will be recorded. Okay. Now let us come to, so it is the parliamentary supremacy or the constitutional supremacy? Somebody say no, it is the constitutional supremacy. It is the constitutional supremacy, they will say. Okay. So the constitutions are there. With that, it is one of the source. Preamble also there. I don't know. Do you have the preamble to the constitution? I think without a preamble, I don't think that you will. Because preamble is the key, ufunguo of the particular act or constitution. So now that is one of the source of it where we can make it out. The second source is statutes. Because I told you, when Rosta has given the sequence, but the sequence is like that. Kwanza chupi, pili skin tight, tatu surwali. Can you reverse it? Kwanza surwali, pili skin tight, tatu chupi. You will become a Superman. You will become a Superman. So, sequence is very much important factor. No, I am not playing Rasta, but I appreciate at least he told. He gave the answer. See, we should appreciate it. Because speaking from that side, speaking from this side is different. This side, Maghumusana. Because this area is 32 kV electric power is there here. So much. And you will forget your name also sometimes. You should come and speak from here. Unless until that you have a good practice. Now let us come to somebody is waiting, Fortuna Gravete, because she joined late, I will get the indication. So always I should be very much careful here, because I am looking at you. If I don't take it now, they are standing in the lobby. Unless I will click it, they don't come into my classroom. It's like a permission. Are you following me? Those who come late. Okay, now notice the statutes are concerned. I will ask you one question. What is the difference between a statute and an act? Anyone? But generally we use it, statute, act, nini, nani. But when you strictly speaking, the act is already we borrowed. But statutes, in both the way you can say, either we can borrow it from or we can amend it or change it. Both we can say. But generally we use it in a synonym way. The act or statutes, we will use in the synonym way. But time being, we'll run the show like this only. A statutes are allow a passed by a parliament in this legislature capacity. But when you say that no, acts are enacted in the parliament, we will say. Acts are enacted in the parliament, we will say. That is the appropriate wordings. And the legislative capacity, statutes can be principal and subsidiary legislations. And principal legislation is there, subsidiary legislations are there. Both the legislations are there. And however, principal legislations allows a passed by the parliament, and subsidiary legislation are normally not passed by the parliament but by the ministers concerned, but some of them are called delegated legislations. Executive make the rules. Not the parliament will make the rules, executive make the rules. Of course, it's passed by the again parliament. If any act to be implemented, it cannot be implemented without the rules. Like act is a engine and bogies. Bogie means compartments. Engine and bogies, compartments. The rules are track. Track, railway track. So without a railway track, the engine will not move. Am I right? It will move on the track only. So rules are must. Without rules, you cannot run the engine on track. Means you cannot move the act or the statute. That's what I want to say. So statutes can be made by the principal statutes are there, subsidiary statutes are there. Generally, subsidiary statutes are made by the executives. But when you say in terms of India, there is a central legislation and a state legislation. Central legislation passes central acts. It is common to each and every state. But state pass its own act. Like land, state laws are there. So if it is I know that the three types of the lists are there. List in the constitution. Concurrent list, Simon? What is the other list? State list, central list, and concurrent list. In state list, general state will take part. In central list, central will take the part. In concurrent list, both. What is the list? Zanzibar and mainland of Tanzania. Anything common or not? In the Zanzibar and Tanzania. There is also a dispute would be there. No, sometimes no. The mainland will control the Zanzibar. So some subjects are central subjects, some subjects are concurrent subject. Both they can maintain it. Of course, currency is only the one, not different currency. But the constitutions are different. Are you following me? So that was the system would be there for the Zanzibar as well as the mainland of Tanzania. And there will say, they say decree. But we don't say decree here. Are you following me? Sir, we don't know where is Zanzibar. Have you been to Zanzibar anywhere? Sir, we did not leave Monza at all. We born in Monza, we die in Monza. Have a big desire. Have a big desire, please. So, statutes are enacted, but generally acts are enacted by the parliament. That is the right wordings. So these acts are there. If any act, any statute which is contrary to the articles of the constitution, it is null and void. Court decides. So now the received laws, the borrowed laws. You know Jala. What is Jala? Loudly. Jala. Say loudly. It will be recorded. Your voice will be recorded. It is also nothing but borrowed, adapted. I don't know exactly the Jala. Judicial adoption of. Why we are worrying that much? Anyone? Yes, that is the Jala. It is an open challenge to each and everybody. I will ask the question now. Jala, Jala, Jala. In abbreviations, there are 4 types of the abbreviations are there. Only Professor Hussain students knows. Other people, Hapana. 4 types of the abbreviations are there. Number 1, because the reference has come, that's why I'm going to give it. Because my students should be like the Professor Hussain. Matana Shati, Amna Kimewo. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. These are all called abbreviations. And Jala, where it fits. Initialism, acronym, shortening, or contraction. Sir, first we don't know what is contraction, what is shortening, how could we make it out, sir? First we explain and give the one model, then we can say that, okay, this is so and so. Okay, I will give the answer. When you pronounce each word separately, J-A-L-A, but we pronounce Jala. We did not say J-A-L-A. We pronounce Jala. When you pronounce all initially as a one word, it is an acronym. Like South. Can you pronounce S-A-U-T? We are not pronouncing. We say South. South is an acronym. But UDSM, we are not pronouncing individual wording that you are using. UDSM, initialism. When you pronounce each letter separately, it is a initialism. When you pronounce as a word, it is the acronym. Then what is shortening? Suppose shortening, you write February. February, you can write F capital, E small letter, B small letter, full stop. That is shortening. Like example, E capital letter, G small letter, full stop. IMP, important. I capital letter, M small letter, P small letter, and full stop. That is called shortening. Then what about the contraction? Sir, we know the contraction because we use in SMS. If you want to say I cannot, you say C-A-N apostrophe T, can't. Cannot. Honorable, H-O-R-H-O-N apostrophe B-L-E, honorable. Q, make a Q. We don't write Q, Q-E-Q, no, Q. That is called shortening. Could not, couldn't. Is it not? INT, int. So, that is called contraction. So, how many type of the abbreviations now you know it? 4. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. Only Professor Hussain students knows this. Open challenge, I will make it out. You go and ask anybody to whom I did not teach. This fellow definitely have heard the lecture of the Professor Hussain. That's why he wants to make experiment on us. Definitely they will say. Anyway, that Jala has come. That's why I would like to share my knowledge with you. And that is the reason. Still 5 minutes are there. Only 5 minutes are there. Afterwards, my class is over. 50 minutes class. Not more than that. I don't teach. Okay, now let us come to the received loss. What we say, Jala is the received loss. And we can say here, doctrine of equity, general applications, we follow as it is from England. And before the reception, that is 22nd July 1920, of the date, resorting back to the review of the law where the gap is spotted in the existing laws. So laws taken directly from the Britishers, they are said to be the received laws. Then customary laws. It depends upon the custom of the Tanganyika. Customs are consisting long-standing usage and practices of the society with an inherent legal force. Customs were applicable in Tanganyika and during the colonial period, and it is a time immemorial. Customs are like a marriage customs, legitimation, children's succession, inheritance, and where we will follow the customary law. And however, not all customary rules becomes a law. No, certain things which are acceptable customs only becomes a law, or it will be codified in the law form, except as a source of law, unless it is not, again, repugnant, means in contravention, repugnant to the Constitution or the rule of natural justice. What is the Latin terminology for the natural justice? You are studying the administrative law. Latin terminology for the natural justice. I will give the equivalent in English. You tell me the Latin. Give the equal opportunity to others to say. Here, adi alterum partem. That is the give equal opportunity to other party to say. For instance, if yes, your children came late and your father punished already because of late. Again mother came. You came late. Again mother wants to punish. Then you know what the son say? Already I was punished by my father. Again you want to punish for the same offense. Double jeopardy. Did you read double jeopardy in the Constitution? For the same cause of action, you cannot be punished twice. Father already punished me. Then you want to punish me. He would say Article 21, double jeopardy. I don't know what article that you are using for double jeopardy. A person cannot be punished twice for the same cause of action. So that is called double jeopardy. And another also, when it is an offense on the particular time, then only we should consider it as an offense. If it is changed over there, we cannot consider it. The time when the offense is committed, it should be an offense at the time. Then only we can consider it, otherwise we cannot consider it. Yes, at any time it will stop it. And this is my style of teaching. Of course, your voice is not recorded over here. Oh, Gopa. So, no Gopa, because straight and forward you can say it. We cannot say the cock and bull stories when the online class are there, because it can be heard by anyone, including the Vice Chancellor, Professor Mahalu. Am I right? Anyone can make it out. Of course, it doesn't mean that you have to teach only the things. Sometimes you can add some other thing also, the spices, so that the class would be the attractive, luring, attempting, impressive. Sister, I did not see some reflections on your face. So, this is the customary. Then we'll take tomorrow Islamic law. Sir, Islamic people are very nice people, sir. They are very fortunate people because they can keep 4 wives.
wabariki viongozi wake, hekima, umoja na amani. Hizi ni ngao zetu Afrika na watu wake. Ibariki Afrika, ibariki Afrika, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Asante sana na sikiliza mimi darasa online. Mungu akubariki na kukulinda.